record, and then we rest.
Okay.
Your Honor,
Don't call a witness yet. Go ahead and stand, but I want you to present any just arguments at this
Your
point.
Honor, I don't believe that the state can rest based on the record. This judge you were not presiding over the last case, and so taking judicial notice of the record, while you can certainly look at the transcripts, you were not there, so I don't see how they can offer no proof other than the transcripts, which they did not attach to their motion, and asked you to take judicial notice of that.
And Your Honor, the next issue is that if we were talking about the motion to quash, and I think that's what we're talking about here, the state's motion is unverified.
Which motion?
We're not talking about a motion to
We're
quash.
talking about the change of venue.
Okay, my sorry.
Yeah, change of venue is the only thing I've got here
Okay.
today. You know, I've read the transcripts, but I can tell you after reading everything, I'm not transferring the case. And so I'm not transferring the case, although I'm a little concerned, and it's not based on the state, it's based on what I've read in the transcript and what arguments y'all have presented to me in court. You've indicated that I don't know exactly how to put it, there's some problems, I guess, maybe some undue influence and that type of thing going on during this trial is what you've indicated. I want to make sure that you're comfortable with having, in other words, if that's going to be a problem, the only way I can really solve it is to move it and get it out of this. I think there's going to be no problem picking a jury, because I think you get Smith County people in here and half of them don't know what's going on in the courthouse and may not even care. I mean, I know it's been covered, you know, media-wise, but you know, you get cases that you think are big cases, even in small counties, and people don't know. So I really don't think there's going to be any problem picking a jury. I'm more concerned about the defendant and your arguments that, you know, it's in the courthouse, we're all in close quarters here, and whether that's going to be a problem.
We agree with with the court, Your Honor, on those issues. We believe we could resolve those. Part of what we intended to do by subpoenaing witnesses, especially witnesses out of the 7th District Court, which of course the OAG's office has responded, and certainly other attorneys are here representing some of those individuals, but what we intended to do at this hearing, if we were to present those witnesses, was to simply ask questions regarding, okay, there have been concerns about things that happened in the last trial. We've brought them up, the state has brought them up in their motion. If this court orders you not to do this, you could follow the court's order and not do that, and I anticipate they would say yes. If the court ordered me not to do X, then yes, I could follow the court's order. And we believe that that would have cleared up any issues that were impediments to the state being able to access their witnesses, and also our issues with the feeling of impropriety or misconduct. And that's what we were going to do by having those witnesses summoned here today.
Okay, well, I'm not going to have them testify, because what I have is the motion to transfer. I can transfer. I looked at the code, and in fact, I've pulled it up on my iPad. I can transfer a case. In this, you know, in the state has a different burden than you have. You know, so it's different every time. If I think it's a problem, I can transfer the case on my own motion. I think that if we caution everybody the way we should in that, I don't think it's going to be a problem. And I really don't think we're going to have a problem getting a jury, because I doubt when the jury comes in, if y'all ask them what they know about it, I'm sure we're going to be able to find 12 or 13 people. Like, y'all see it an alternate when y'all?
We do, Your Honor.
Okay, 12 or 13 people pretty easily.
And we agree we had no issue last time.
Okay, so we're leaving it in Smith County.
Okay.
It's more convenient for the parties as well.
State's requesting a trial date then?
I would like to get it set for trial. Do y'all?
Can we also bring in the witnesses at the end of this hearing and admonish them, since they are under the rule, and before we break for the day, because they will be testifying in the trial.
Judge, I'm going to object to that. The rules are very specific to one hearing at a time. They're not just randomly under the rule for the next 6 months.
I think that's true. I don't think I can put them under a rule for 6 months. I think it's, but when we start next time, we'll get them all in here. I'll swear them in. We'll get their names on the record and make sure it's clear that they understand what the rule requires.
May we also clear up one other issue, since we do have a representative here from Austin today?
Oh, are you from Austin?
He is.
Okay, I'm sorry. I didn't even get you to introduce yourself. What's your name, sir?
Mason Kura, the Office of the Attorney General.
Okay.
Your Honor, the state did make it apparent in the last trial that they did not intend on calling Judge Kerry Russell in their case. However, we will be subpoenaing him for trial as a witness, as a fact witness. He's the complaining witness and the alleged victim in the indictment. We will want to call him even if they do not. Is this going to be a recurring issue where there's going to be another motion to quash filed by the OAG's office, or is this something that is just specific to this hearing only?
he may not be able to answer that question, but I'll let him speak for himself.
I can't answer as to whether there would be a motion to quash for any subsequent subpoena. We only filed one for this specific subpoena for this hearing.
I'm going to grant it for today, but he is the named victim in the indictment,
Yeah, I can
so.
tell you he's available for trial, so.
Okay. I mean, I read this, I got here early and I read it, and most of what is indicated in here wouldn't apply to the fact that he was a fact witness and the underlying victim in the case. I mean, in my opinion, you know.
That's exactly right.
If you're gonna file a motion to quash when he gets it, you might get it to me a little bit early so we can take it up before we're actually ready for trial. You know, okay? Or you can go back and like confer with whoever on that you need to. What are y'all thinking about a trial?
I think we were talking about that October, I don't know if you had October dates. I can't.
I gave Kaylee a whole random amount of
So I got a
dates.
mixed list from everybody of what can work and what can't work, and no one added up correct. No one's,
Oh,
none of the dates
The
matched.
defense team, we're pretty good in October. I have a pretrial on the 9th of October. That's it.
I'm on vacation October 12th to the 15th.
Okay, but let me look at me. I
I was
know,
gonna say, I think the 23rd is the only thing that the 114th courtroom.
oh, the courtroom. And that was another reason I didn't want to transfer the case, is trying to find a courtroom that's using another, yeah, it was the courtroom.
For the rest of this year, the 114th courtroom is only available October 23rd and November 27th.
We could do October the 23rd.
Yes, we can.
That is the only time until we
You
have
can
to
do
push it.
I can.
Good, let's do it.
You can?
The pretrial would typically be October 13th, but we can move it.
Tinter won't be there.
Right.
No one who knows.
We could do it.
Move it around on her vacation, but the 23rd
Right.
would be fine with me.
We could do pretrial October 6th or October 9th.
October 6th is better.
Okay.
The 6th.
Great.
Okay, let me put that, well, good, we got something resolved today. That'll be good, y'all be glad to get this done, because this case is what, is it 3 years old?
So that pretrial on the 6th, what time would that be?
Make it,
8:30. Or, wait, no, what?
I'll drive
what
like
time-
2.5
yeah.
hours,
Yeah,
so
what-
maybe
so
10:30? I mean, I don't want to mess
Sure.
up y'all's schedule, or in the afternoon.
10:30 is fine.
Okay.
That's fine.
And then it has to be 8:30 in the morning.
Oh, yeah, yes, I understand for trial, that'll just be 8:30. Hey, how do y'all do y'all have a central jury panel? I mean,
The qualification room downstairs.
do they do that on Monday, or do they do that before Monday?
That's early Monday morning.
Okay, and then they send you a panel
Yes.
of what, 36 or 42?
They'll fill up the whole
90.
courtroom.
No, okay, good, yeah.
And so we do the whole jury, the real jury selection is in here.
The board
We
and
don't
everything.
participate in the qualifications or.
Right.
I like that. I don't like doing qualifications and exemptions, so I'm all for somebody else doing
Some
that,
other
you know.
judges
I can
do
have
that.
one of our other judges besides Judge Jackson to qualify that Monday.
Would that be okay for
Yeah, that'd be
them?
fine, and that way we can actually start this to give you time to get here at 10 o'clock.
Oh, good, okay.
And so
So
that
not
way,
Judge Russell either, please.
No, it will
Yeah.
be Judge
yeah,
Gardner.
no, it will be
Not
Judge Gardner.
Yeah, because the qualification takes a couple hours.
Yeah, because you qualify a number of panels, right?
Right.
Yes.
Yeah.
And
They
they
qualify
have
no more
to- and they
panels.
have to make the list and
That's
put
a
them in
long,
order.
Yeah.
a
So
long
it'll-
process.
We won't have a list
Qualification
until-
usually starts about 9:15. We usually maybe get a list back at 10:15, 10:30.
So the
Okay.
next question we might want to think about is, let's say we get a panel in here and let's say we get a jury picked by noon or maybe 1 or 2 o'clock. Do we want to do opening statements that day or do we do them that?
I want to do however y'all want to do. I usually will start that day, but I'm always under a lot of time pressure. You know what, and normally, like, I'm trying to get finished by Thursday so I can start another, but however y'all want to do it, it's fine with me. Whatever Kaylee tells me or what y'all tell me.
More than likely, we won't be able to start opening board hour until maybe 11 or after lunch at 1.
So we won't.
Okay.
So I highly doubt we would ever.
We'll do voir dire that day and then start our testimony the next day
I
then.
think
Plus,
that's-
if y'all have any pre-trials for the morning of, if we're not gonna start till 10, we still need to give y'all time to go over the list of people, so.
So
we're gonna probably-
Monday, voir dire, first witness is opening and first witness is Tuesday.
Correct.
Yes.
That's fine.
That way, if we have some other things we need to discuss.
It's whatever we
Oh,
have time
I mean,
for. It doesn't matter to us.
Yeah, we won't know what that date is.
Oh, I know, and voir dire always is, you know, you never really know. If you get a lot of people that want to talk or have information, then.
Wait, we'll subpoena witnesses for Tuesday.
Do you want me to haul all the witnesses back in here and tell them they're released from the rule for today?
Yes, please.
Okay.